Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Tony Collins, an attorney in Texas. The Legal Connection Show can be heard on FM 104.5 and FM 106.1 Tuesdays at noon. And if you miss the show, you can also catch us on Facebook, The Legal Connection Show, or you can also watch this show or listen to the show on irlonestar.com. They have all of the replays of the show. We're also on YouTube if you just Google the legalconnectionshow.com. Now, what we do is we cover legal issues that are of interest to the community. And I say we, my co-host Cheryl Jahani hasn't been here for a while. She's still recuperating from a personal issues that she's had that it just takes some time when you have problems that you need to work through. But I talked to her daughter today, and she requested that we sort of demystify Roe versus Wade, and so that's what we're going to do today. Recently, there was, in the news that a landmark opinion, Roe versus Wade, was going to be overturned by the current Supreme Court 50 years later. And, when I was 10 or 11 is when this came out. And of course, I didn't know anything about Roe versus Wade. It wasn't something I was familiar with. I was in the 5th grade. During the period when this particular case went to court was when we had a conservative President Nixon. He was very popular. I do recall that. And we were in the throes of the Vietnam War, and it was during sort of that Woodstock era where there's lots of hippies and stuff. And I think Saturday Night Live was just coming together, the National Lampoon, at National Harvard Lampoon, I think is what it was. A lot of things were going on during that strifeful period. Not that we don't have that now, but it's come to the forefront again because there was allegedly a leaked opinion that it would be overturned, and the majority opinion was written by Supreme Court Justice Alito, who is our Fifth Circuit judge, so out of New Orleans. So that was of interest to me too. And so what I did was, I was too young to really understand all the background of Roe versus Wade. Of course, I learned about it in law school, but I never read the opinion, and I thought it would be helpful for our listeners to actually make an assessment on their own based on the actual case, and to determine whether or not it was based on the opinions that they used in the legal precedent, if it was a bad decision. So that's what I did. I pulled together information on the original Roe versus Wade so that y'all can hear it and not just be hearing the name and then hearing stuff on the news and not really understanding it. So, all right. So Roe versus Wade was a 1971 to 1973, and they put a hyphen, like it's 2 years old, landmark decision by the U.S. Supreme Court. It ruled that a state law that banned abortion was unconstitutional. And the 7-2 decision, so that's a majority, that's 7 full Supreme Court justices out of 9, in a 7-2 decision, had Chief Justice Warren Burger and 6 other justices vote for Jane Roe, and Justices William Rehnquist and Byron White vote against it. In other words, Jane Roe, and we're going to hear a little bit more about her and that pseudonym that's used for her later, they decided that it was her right to have an abortion, all right, and against state law. But we're going to get a little bit more into that because the case itself is very clear. Just you don't get to hear about the actual case until now. The decision divided the United States and is still controversial 50 years later. People became divided into pro-life and pro-choice groups. Pro-life supporters argue that the unborn baby has the same right to life as other people. and the government should intervene to protect it. Pro-choice supporters believe that the unborn baby is not the same as a person, and the woman that's carrying the baby has the right to choose what she wants to do with her body, and that the government should not intervene. Roe was limited by a later decision, Webster versus Reproductive Health Services in 1989, which allowed the regulation of abortion in some cases. Several states have considered laws of banning abortions altogether. In May 2022, that's right now, a leaked draft of the Supreme Court's decision to overrule Roe versus Wade was published. And it goes on to say that it was published by, let me see, I'm going to look at the footnote here. Get to that over here. It says it was published by, well, of course, it doesn't give me where the footnote is on this, but we'll get to that. All right, the background. The case began in 1970 when most of our listeners were either not old enough to care or were not alive, in Texas, as a challenge against a law banning any kind of abortion unless the mother's life was in danger. A pregnant Texas woman, Norma McCorvey, alias Jane Roe. That's why it's called Roe. They didn't want to name her name at the time, and she later came out, and it was disclosed what her real name was. Norma McCorvey brought a lawsuit against Henry Wade, the Dallas County District Attorney, in a Texas federal court, claiming to be a single woman and pregnant. McCorvey wanted to terminate her pregnancy. She wanted it done safely by a doctor, but said that she could not afford to travel outside of Texas. She could not get a legal abortion in Texas because her life was not in danger. So there was a law in Texas that required that the only way you could have a legal abortion is if your life was in danger. And it seems to me that she could have lied about that, but she chose not to. She could, it says, her lawsuit claimed that Texas law violated her constitutional right to privacy, protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. 5 amendments. And those are amendments to the Constitution from, I guess, 1889? I don't think the 14th Amendment was sometime later. Roe added that she sued on behalf of herself and all other women in the same situation as she was. The case slowly made its way to the Supreme Court. Meanwhile, McCorvey had her baby and placed it up for adoption. So she didn't get the benefit of her own case. She actually had the baby. And you know, no harm, no foul. She had the baby and she gave it up for adoption. And I guess we're going to learn a little bit about what happened later, historically, to that baby that she had in 1970, who would now be 50 years old. In the majority opinion, in a 7-2 decision, the court held that a woman's right to an abortion was protected by her right to privacy under the 14th Amendment. The decision allowed a woman to decide whether or not to have an abortion during the first trimester. That affected laws of 46 states. And, you know, lots of laws have been passed, even now, that said that you can't even have an abortion in the first trimester. But this is pretty limited. You can have an abortion if you find out in time to be able to terminate the pregnancy within the first, I believe it's first trimester is 12 weeks. I may have my numbers wrong, and we'll get a little bit more into that because I'll talk about it. Justice Harry Blackmun wrote the majority opinion. I'm not even sure if he's still alive. We acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep, seemingly absolute convictions that the subject inspires. And he wrote this in 1973. And I just will add a footnote, or a sidebar, not a footnote, that it's interesting that the woman was from Texas, and Texas originated this case that's been so controversial and has been a landmark decision and still is since about 72. All right, so the dissenting opinion was written by Justice Rehnquist, who disagreed with the majority for several reasons, and this is probably why the case is being overturned now. So these are important points. He first pointed out that there was no legitimate plaintiff in the case, which was a requirement to hear the case. A legitimate plaintiff would be a woman in her first trimester of pregnancy at some point while the case was being tried. McCorvey, also known as Jane Roe, did not fit that qualification, and so the ruling had no application to the case. clearly, she had the baby in probably 1970, so by the time it went to the Supreme Court or even the federal district court, it wasn't ripe anymore for her. She wasn't a legitimate plaintiff, which would be the way it would always work out because justice is slow. If you were, it takes 9 to 10 months. Actually, it's 10 months to, to conceive and have a baby. So in this case, though, they heard it. The court recognized as the second point in the dissenting opinion that a woman's right to an abortion under a general right to privacy from previous cases. However, he argued, Justice Rehnquist, a transaction such as this is hardly private in the ordinary uses of the word. The third argument was the majority opinion was vague on the exact place of the right to privacy in the Constitution. Several amendments were mentioned, but none was specifically identified to contain the right to privacy. The word privacy is not found in the Constitution. Fourth, additional problems include the court acting as a legislature in dividing pregnancy into 3 trimesters and outlining the permissible restrictions that states may make. He pointed out that 36 of the 37 states in 1868, when the 14th Amendment was passed, so it wasn't 1789, it was 1868. 14th Amendment's pretty old, had laws against abortion. So as far back as 1868, that's well over 100 years ago, well over 150 years ago, had laws against abortion. And this included Texas. The only conclusion possible from this history is that the drafters of the Constitution did not intend to have the 14th Amendment withdraw from the states the power to legislate with respect to this matter. So it's a 10th Amendment issue because anything that's not given the 10th Amendment, and I'm paraphrasing here, it's only one sentence long, but any rights not specifically given to the federal government belong to the state. And so abortion rights are a state issue, as are many other rights. Now, the right to privacy interpretation is critical. It was critical back in 1972, and I believe it probably will be here in 2022. The basis for the right to privacy is a judicial interpretation that can be traced from an earlier case, Griswold versus Connecticut in 1965. It's only a few years before Roe versus Wade. In that landmark case, the Supreme Court ruled that a Connecticut law against the use of contraceptives violated the right to privacy, as found in the Constitution. However, the right to privacy is not directly mentioned in the Constitution. The Supreme Court decided that the right to privacy is implied by several amendments. In 1923, the court interpreted the liberty guarantee in the 14th Amendment as a broad right to privacy. So we're going to drop down from, the 10th Amendment rights. I mean, they're arguing all over the board. They're basically torturing the law to get to a solution. And I will just say that without reading a little bit more of this, as another sidebar, that Justice Alito is a very good and astute Supreme Court justice. And so I expect, even though we have not seen the draft of this opinion yet, that it may very well just follow the letter of the law of the Constitution. Don't know that yet. Justice William O. Douglas stated that the guarantees of the right to privacy had penumbras, that's, I believe Latin for implied rights, formed by emanations, that's also a long word for a flowing, from those guarantees that help give them life and substance, the amendments. Okay, so the trimester concept. In its decision in 1972, the court used the 3-trimester framework of pregnancy. During the first trimester, an abortion was safer for the mother than childbirth. The reasoning was that the decision whether to get an abortion at this stage should be left up to the mother to decide. And that's how Roe versus Wade came about, that it's safe for the mother, it's not harmful to an unborn fetus. I guess they were trying to determine when life occurred, which none of us know, only God. Any law that interpreted with abortions, any law that interfered with abortions in the first trimester would be presumed to be unconstitutional. During the second trimester, the laws could regulate abortion only to protect the health of the mother. During the third trimester, the unborn child was viable, and that means able to live on its own outside the mother's womb. Then laws could restrict or prohibit abortions unless it was necessary to preserve the mother's health. The doctrine stood until 1992, when Planned Parenthood versus Casey had the court now based the legality of an abortion no longer on trimesters, but on fetal viability. So back in 1972, the Supreme Court was actually making an assessment of when a child was viable in the womb. And they decided that it wasn't viable in the first trimester and wasn't viable in the second trimester. But they were making decisions based on the mother's health. So the overruling is the next segment here. And this is the gist of what we're going to talk about today after I actually read the opinion so you can make your own decision. On May 2nd, 2022, Politico, which is a political newspaper that I guess gets leaked information. It used to be the Washington Post and the New York Times and various other news distributors, news agencies, but now it's Politico. Politico was given a leaked initial draft majority opinion written by Justice Samuel Alito, suggesting that the Supreme Court is and will overturn Roe and Casey in a pending final decision on Dobbs versus Jackson Women's Health Organization. So that's the case before the court right now. They are allegedly going to overturn the law that they made in 72 from. The leak also renewed calls on the U.S. Senate to pass legislation already passed by the House of Representatives to codify the rights created by Roe before the Dobbs decision is formally published. So in other words, there are many, I don't want to say pundits, there are lobbyists that are trying to quickly get the U.S. Senate, while it's all Democratic, and the Congress to go forward and so the legislature can pass laws, and this would be federal, it's really a state law, so I don't know why they're going to federal, to ensure that a woman has the right to get an abortion under the different state laws, so that this Supreme Court ruling won't interfere with the state rights, and I guess here it would be the federal rights, and that they would have to go to court again for the Supreme Court to review it again to make this Dobbs versus Jackson Women's Health Organization not apply. So now I looked everywhere for the leaked opinion, and when I tried to pull it up on Politico, I got references to it as opposed to the actual opinion, which I wanted to read. It will apparently be out soon enough, and just as another sidebar, I just filed a petition for a writ of certiorari with the U.S. Supreme Court, and I wanted so badly to add at the last sentence, this is so much less controversial, just go ahead and grant my petition for this writ, so that we can get on with a law that you've already found in previous cases is supported by your decision. So I didn't put that in there, though, because I didn't want to taint my own opinion that I just petition that is wrote for a writ to make it political, which the U.S. Supreme Court is highly political. At any rate, the original Roe versus Wade ruling was leaked too, and this was NPR is what I'm reading through. It was an article that was written on May 3rd, and I thought that was kind of interesting that politics never change even 50 years later. The news site Politico sent shockwaves across the country on Monday night, which was, I guess, May 2nd, when it published what appears to be an initial draft majority opinion written by Justice Alito and reportedly circulated inside the court, suggesting that the U.S. Supreme Court intends to strike down Roe versus Wade. And again, I can't find it. I wish I could read the new opinion to you, but it's not out yet. And then, again, you can't rely upon things that are leaked because they may be changed and they may not be authentic, so I'll wait for the real decision to come out. Chief Justice John Roberts confirmed the authenticity of the document in a statement on Tuesday morning, but says it does not represent the court's final position. He also ordered the Supreme Court marshal to investigate the leak. NPR legal affairs correspondent Nina Totenberg told Good Morning, the morning edition of, I guess, the NPR, that it really smells like, looks like, and feels like the real thing, this leaked opinion. Striking down Roe effectively would end federal protection for abortion rights, opening the door for states to ban or restrict access to the procedure. And I'm going to read that again because it's even confusing to me. Striking down Roe, 1972 opinion that allows abortions because they said it's unconstitutional to prohibit a woman from making the decision about her own body, would end federal protection for abortion rights, opening the doors for states to ban or restrict access to the procedure. So they're saying that this effectively would allow states like Texas and Alabama and Louisiana to ban abortions. While such a ruling would have enormous consequences, legal experts and onlookers alike are also struck by how the draft opinion made its way into the public view in the first place. Leaks of any kind are rare in the Supreme Court, and Totenberg says that there hasn't been such a massive breach in modern history. She called it, well, of course, there was one, I guess, not in modern history. The last one that at least I'm aware of is one that occurred in 1972, this one. She called it a bomb at the court, that it undermines everything that the body stands for internally and institutionally, the Supreme Court is what she's referring to, including its members' trust in their law clerks and each other. No fully formed draft opinion has been leaked to the press or outside the court, Totenberg says. Once or twice, there may have been leaks that say how something's going to turn out, or after the fact that somebody may have changed his or her mind. But this was a full-blown Pentagon Papers, like Watergate, type compromise of the court's work. There were actually 2 Roe-related leaks. There have indeed been leaks at the court before, albeit of a different scale. One of them actually was about the case at heart of today's conversation. In 1973, the original Roe decision was leaked to the press before the court had formally announced it. Jonathan Peters, a media law professor at the University of Georgia, noted in a Twitter thread that there was actually 2 Roe-related leaks in the 1970s. First, the Washington Post published a story about the court's internal deliberations, including a June 1972 memo from Justice Douglas to his colleagues that was mysteriously leaked. And remember, the Washington Post is the same group in 1972 that uncovered Watergate, which was the downfall of Nixon and prompted him to resign as opposed to being impeached. 7 months later, in 1972, Time magazine published the final decision and vote details just hours before the court was due to announce it. The result was an early scoop and a delayed ruling, so Time really got the scoop on that. A Supreme Court clerk named Larry Hammond told the Time staffer reporter David Beckwith, a law school acquaintance, that the Roe ruling was coming, according to a lawyer and author, James Robinault, who detailed the incident in the Washington Post column on Monday. Hammond gave Beckwith with the information on the background and was only to be reported once the opinion came down from the court. But the ruling was slightly delayed, and the week's magazine ended up hitting the newsstands a few hours too soon. Right. And so it was published, against what their agreement had been. Now, this is called the 22nd rule of the double cross. Then Chief Justice Warren Burger was reportedly furious about the leak, demanding a meeting with the Times editors to tell them off. He also sent a letter to the other justices demanding that the leaker be identified and punished, and threatened to subject law clerks to a lie detector test if no one came forward, Robinault said. According to Peters, this was also the origin of Burger's 22nd rule, in which any law clerk caught talking to the reporter would be fired in and under a half minute. Huh. Oh, well. It says, I wonder if they have that rule now. You would think. The press is pretty liberal. So they probably don't have that rule. In fact, they probably get a commentation now for leaks. Activists look forward to what could be the last anniversary for Roe. So Hammond offered his resignation to his boss at the time, Justice Lewis Powell. I guess I didn't know that. Let's see, Hammond couldn't be the New York Times worker. Hammond was, let me go back. I don't want to say this out of course here. A Supreme Court clerk. So Hammond was a clerk for Justice Powell, and he handed his resignation. But Powell didn't accept it and instead called Berger to tell him that Hammond had been double-crossed. And writes Robinault, who interviewed Hammond for one of his books published in 2015 about the political and cultural events of January 1973, which, of course, we've already discussed briefly, was in a very, if you think times are different now with COVID and China and Russia, 73 was in the midst of the Vietnam War and the Watergate issue, and Woodstock, and it was how things change and things remain the same as history repeats itself. Anyway, Berger wasn't quick to forgive the magazine, but accepted Hammond's apology, let him stay on as Powell's clerk. He continued in that role for an additional term before the court, leaving the court to join the Watergate Special Prosecution Force, which happened right after that. So he didn't stay on for long. The story of Hammond's close call became legend to other clerks in the court at the time and had been passed down as cautionary tale over time. 5 decades later, the court is once again grappling with the initial leak about an unreleased ruling on matters concerning reproductive rights. Totenberg had predicted on Morning Edition this week that the court would try internally to figure out who leaked the document, noting that while such a leak isn't a crime, it's a career ender for whoever did the leak. Which I can see that, because while we have a somewhat conservative court, we've got an extremely liberal political climate and the press. So, and that being said, there was an article in the paper today that was quoting the Harris County attorney. What is her name? I can't remember. She's always in trouble for newly elected, just out of law school, really didn't have any background, got elected as attorney. Hidalgo, the Harris County Attorney Hidalgo, had held a press conference saying that she believed that the leaked opinion is all wrong. They got the law wrong. It's really bad, and I printed it and then I left it in my car. But I'm going to let you make your decision on whether you think the law is wrong by reading you the original Roe versus Wade. And because it kind of puts it all in perspective, I gave you sort of a highlight, but this is going to tell you the legal premise for why Roe versus Wade was, I believe that it was legal gymnastics to get to this decision based on just the constitutional, 5 different constitutional amendments instead of just one, and basing the ruling on the word, the privacy of the individual when that's not even in the Constitution. But here you go. All right. This is Roe versus Wade. It's a Supreme Court. It's Jane Roe, who we now know as McCorvey, versus Henry Wade, who was the Dallas District Attorney. And it can be found under the U.S. Supreme Court 410 U.S. 113. But it's easier to Wikipedia it, and you can just link to it. It was argued in December 13th, 1971, re-argued October 11th, 1972, so nearly a year later, and decided just a few months after that on January 22nd, 1973. A rehearing was denied in very short order a month later on February 26th, 1973. All right, so here's just the gist of it as they actually published in the opinion. A pregnant single woman, Roe, brought a class action challenging the constitutionality of the Texas criminal abortion law. So this is criminal law. Which prescribe procuring or attempting an abortion except on medical advice for the purpose of saving the mother's life. So you would have to know what doctor and be able to have that doctor say that it was a medical emergency, which I don't believe would be all that difficult, to be honest with you, because you can get almost any doctor to write you a prescription to have one of the animals that what are they called, the support animals, if you get a doctor to write you a prescription or a note to an apartment complex or an airline, you can actually get an emotional support animal buy on your pets, even if you really don't need one. But much like saying that you've got post-traumatic stress syndrome, or maybe you've got an eating disorder, or maybe you've got some sort of like Amber Heard and marginal, or I forgot what they call it, marginal personality disorder. It's not called that. It's a you could find any reason, but a doctor could give you notice. So you could give notice through this. It says licensed physician, Dr. Halford, who had 2 state abortion prosecutions pending against him, was permitted to intervene. A childless married couple, the Does, they didn't discuss their name, the wife not being pregnant, separately attacked the laws, basing the alleged injury on the future possibilities of contraceptive failure, pregnancy, unpreparedness for parenthood, and impairment of the wife's health. So I'm going to read that again because that was kind of important. A childless married couple, the Does, the wife not being pregnant, separately attacked the abortion laws, the laws that did not allow abortion, basing the alleged injury on the future possibilities of contraceptive failure, pregnancy, unpreparedness for parenthood, and impairment of the wife's health. So the Does were pro-choice. A 3-judge district court, which consolidated the actions, held that Roe, who's also, we know now, her real name's McCorvey, and Dr. Halford, who was supporting Roe in saying that abortions should be allowed, and members of their classes had standing to sue and presented justiciable controversies, ruling that declaratory, though not injunctive, relief was warranted. The court declared abortion statutes void as vague and overly broad, infringing those plaintiffs' 9th and 14th Amendment rights. So they used the 9th, not the state rights, which is kind of surprising. The 9th and the 14th Amendments, their constitutional rights were being violated by not allowing them to have an abortion. The court ruled that the Doe's complaint not justiciable. So I guess they decided that the lady that wasn't pregnant, that was just supportive, the Doe family, didn't have standing. The appellants directly appealed to the court, that would be the district attorney of Dallas, appealed to the court on the injunctive rulings, and the appellate cross-appealed from the district court's grant of declaratory relief to the Roe and Halford, and they held. 1. While Section 28 of the United States Code, I'm sorry, it's not the section, but it's section 1253. It's how I forget this. It's the Code 28 of the U.S. Code at Section 1253 authorizes no direct appeal to this court from the grant or denial of declaratory relief alone. Review is not, this is the way this is worded, really funny. Review is not foreclosed when the case is properly before the court on appeal from a specific denial or injunctive relief, and the arguments as to both injunctive and declaratory relief are necessarily identical. And, I know this is written properly because they've got so many people that are going over these cases and crossing the T's and dotting the I's, but that sure did read funny to me. It says, 2, Roe has standing to sue. The Does and Halford do not. Contrary to the appellee's contention, the natural termination of Roe's pregnancy did not moot her suit. Litigation involving pregnancy, which is capable of repetition, yet evading review, is an exception to the usual federal rule that an actual controversy must exist at review stages and not simply when the action is initiated. So basically that was how they got around allowing Roe, who was no longer pregnant, case to show that it was justiciable and that she had standing, even though she was no longer pregnant, because it's going to happen over and over again. The district court correctly refused injunctive, but erred in granting declaratory relief to Halford. So they correctly refused the injunctive relief, but erred in granting a declaratory. So they're saying that Halford should have been heard, who alleged no federal protection right not assertable as a defense against the good faith state prosecutions pending against him. So the reason that they said that he could get declaratory judgment, which makes sense, is because he was being sued not to do abortions. So they let him go forward too. So it was Roe and others versus Way, the district attorney in this case. So it wasn't just Roe. She wasn't by herself. The Doe's complaint, based on its own contingencies, any one or more of which may not occur, is too speculative to present an actual case or controversy. So what I just read you basically said, the woman who was pregnant that had her baby and gave it for adoption, she could be before the court because she had standing, because it could happen again. So that was an exception to the rule that you had to have an actual pending controversy that needed to be relieved. The district court said that the doctor was being sued, and so he also had standing because he had a right to defend or get declaratory relief, saying that he didn't do anything wrong with these criminal laws. But they didn't let the Does, who were just, Joe family that, wanted to, carry their flag and argue that this was unconstitutional, because they didn't have a complaint. They just had an opinion. So the case went forward with the doctor and with the gal that had been pregnant. Now, state criminal abortion laws, like those involved here, that accept from criminality only a life-saving procedure on the mother's behalf without regard to the state of her pregnancy and other interests involved, the court is saying do violate the due process clause of the 14th Amendment, which protects against state action the right to privacy, including a woman's qualified right to terminate her pregnancy. Though the state cannot override that right, it has a legitimate interest in protecting both the pregnant woman's health and the potentiality of human life, each of which interest grows and reaches a compelling point at various stages of the woman's approach to the term. So this is where they're I think, creating legal gymnastics, because they're saying that they're protecting the woman's right and the potential life of the fetus, but they're dividing when they're making a godlike determination of when the fetus's life has viability. And I would think now, in 2022, the Supreme Court would be in a better position to glean and be more on point on when life is more viable, because our technology in medicine has evolved over 50 years to be able to make a better assessment of when a child's life is viable. Just guessing here, but I'm thinking that maybe the direction they were going with the new case that allegedly will overturn Roe. Okay, so it says that in the actual opinion that I'm reading, that for the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. So they're going to completely allow a woman's physician, and that could be someone that does abortions at a medical clinic, determine whether or not in the medical judgment that the woman can end her pregnancy and not hurt her own health. For the stage subsequent to the first end of the trimester, the state, in promoting the interest and health of the mother, may, if it chooses, regulate the abortion procedure in ways that are reasonably related to the maternal health. So in Roe, they're allowing the state to step in, and rightfully so, because the federal law doesn't have anything to do with this, that it would not be unconstitutional for a state to make different laws on regulating abortions in the second trimester. So in this case, you might have had to go to a different state to get an abortion, because even Roe didn't prevent that here, only the first trimester. And then the state may define the term physician to mean only a physician currently licensed by that state, and may prescribe any abortion by a person who is not a physician as so defined. So I'm going to read that again. The state may define the term physician as to mean only a physician currently licensed in that particular state where the abortion is being sought out. So if you needed abortion in Texas, and state laws are Texas laws are now very strong, then the state could prescribe any abortion by a person who is not physicians. The state would be able to regulate that. It is unnecessary to decide the injunctive relief issue since the Texas authorities will doubtless fully recognize the state's ruling that Texas criminal abortion statutes are unconstitutional. And I'm going to read that again because that's really important. It is unnecessary to decide the injunctive relief issue since the state authorities will doubtless fully recognize the court's ruling that Texas criminal abortion statutes are unconstitutional. Because they're saying that the way the law was written at that time, that prohibiting an abortion in the first trimester, that the Supreme Court is saying them, they're giving them the lay of the land. You cannot overrule this law. All right, and so this particular opinion goes on for pages and pages. Looks like it's about 50 pages long, and I've only got 5 more minutes according to Station Manager Dick. But I will read a little bit more about it. I've given you the gist of the case, though. It says that this federal appeal and its Georgia companion, Doe versus Bolton, and this was the reason it ended up as a federal appeal is because Doe, who was McCarvey, and Dr. Halford had sued in a class action, which is a federal type action, had sued a district attorney, saying that the district attorney that representing the state that the laws in Texas were unconstitutional, and that's the method of getting into the federal court. The federal court brought it to the Supreme Court level because that's the next level of appeal. Well, actually, the next level of appeal is the Fifth Circuit in Texas. So we're going to get down to that as far as the procedural reasons why this made it to the Supreme Court. The Texas federal appeal and its Georgia companion present constitutional challenge to the state criminal abortion legislation. The Texas statutes under attack here are typical of those that have been in effect in many states for approximately a century. The Georgia statutes, in contrast, have a modern cast and are a legislative product that, to an extent at least, obviously reflects the influences of a recent attitudinal change in 1972 of advancing medical knowledge and techniques and of new thinking about an old issue. Now remember, we're talking now, not about Roe, the one I'm reading to you right now, but we're talking about the same application, advancing medical knowledge and techniques of new 50 years later on an old issue. Which may be why it was also overturned because we have more medical knowledge now. Then the court in 72 said, we forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the rigorous supposed views, even among physicians, and of the deep, seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes toward life and family and their values, and the moral standards one establishes and seeks to observe are all likely to influence and to color one's thinking and the conclusions about abortion. In addition, population growth, pollution, poverty, and racial overtones tend to complicate and not simplify the problem. Our task in 1972, of course, is to resolve the issue of constitutional measurement, free of emotion and of predilection. We seek earnestly to do this, and because we do, we have inquired into, in this opinion, place some emphasis upon medical and medical legal history and what that history reveals about man's attitudes toward the abortion procedure over the centuries. We bear in mind, too, Mr. Justice Holmes' admonition in his now vindicated dissent in Lochner v. New York, which he wrote in 1905. He was Supreme Court chief in 1905. The Constitution is made for people of fundamentally differing views, and the accident of our finding certain opinions natural and familiar or novel, and even shocking, ought not to conclude our judgment upon the question of whether statutes embodying them conflict with the Constitution of the United States. The Texas statutes that concern us here are the state Texas penal codes, and their articles 1191 versus 1194 and 1196. They may have been renumbered, though, so they're probably going to be different in the new opinion. And these make it a crime to procure an abortion as therein defined or attempt one, except with respect to an abortion procured or attempted by medical advice for the purpose of saving the life of a mother. Similar statutes are existent in the majority of the states. Texas first enacted a criminal abortion statute in 1854. And that's right after we became a state in the United States. Texas became a state in 1845. And then we had the Civil War, of course, in 1860. So just kind of put this in perspective when this law was passed, Texas law. This was soon modified into language that has remained substantially unchanged to the present time. The final article in each of these complicated compilations provided the same exception as does the present Article 1196 for an abortion by medical advice for the purpose of saving the life of the mother. This goes on to say Jane Doe was a single woman who was residing in Dallas County. Texas instituted this federal action. So Jane Doe instituted this federal action in March of 1970 against the district attorney of that county. She sought a declaratory judgment that the Texas criminal abortion statutes were unconstitutional in their face and an injunction restraining the defendant from enforcing the statutes. In other words, Texas could not find that it was criminal for her to have an abortion. Roe alleged that she was unmarried and pregnant and that she was to terminate her pregnancy by an abortion performed by a competent licensed physician under safe clinical conditions, and that she was unable to get a legal abortion in Texas because her life did not appear to be threatened by the continuation of her pregnancy, and she could not afford to travel to another jurisdiction in order to secure a legal abortion under safe conditions, which is a little bit odd because Dallas is up there right by Oklahoma and Arkansas. She claimed that Texas statutes were unconstitutionally vague and that they abridged her right to personal privacy protected by 1st, 4th, 5th, 9th, and 14th Amendments. By an amendment to her complaint, Roe purported to sue on behalf of herself and other women similarly situated. And I know I'm probably about out of time, but I want to continue reading this case for y'all. But I'm going to say, without having read the leaked drafts, that it has to turn on because Justice Alito is extremely fair-minded and very logical. It must turn on the new medical technology. Just guessing that technology or the medical information that we have 50 years later to, or it could turn on or maybe both, that privacy is not even set out in the Constitution, and so maybe it has been interpreted differently. I kind of find that hard to believe because you'd have to have at least 5 of the justices that would have been a majority. He just wrote the opinion. I think it probably goes more toward medical technology now and determining whether or not there's a viability to a fetus in the first trimester. And I believe that from what I've heard, there is viability because you can get a heartbeat, and we've got such new technology showing that a baby can survive even in the first trimester. So, but I'm not going to make that decision because I'm not a doctor. I don't know anything about it. I don't know what's been leaked. But we are going to continue this next week, where I'm actually going to read to you the opinion so you can make the assessment on your own on whether or not Roe v. Wade was constitutional and whether or not if it really is overturned, which apparently these NPR and Politico and these different sources are saying that it was a legitimate leak, just like it was in 1972. That they will give you a lot more clarity than I will certainly be able to on what the decision is, on what is really going on with Roe versus Wade. So I'm being told to wrap up by Station Manager Dick. We are going to finish reading the first row, and then maybe by the time the leaked opinion will be out, and we can discuss that in our next show. I will see you next time on next Tuesday at noon. And remember, the most important thing you can do is serve God by serving others. See you next week.